We'll start the webinar at 10:40 a.m. sharply. Good morning, everyone. On behalf of Tamil Nadu Legal Rights Consortium, I warmly welcome you all to today's webinar on Force in Practice, Understanding Rights, Responsibilities, and Realities. We are truly delighted to see you all here this morning. The Tamil Nadu Legal Rights Consortium, under National Legal Rights Consortium (WICCI), works towards spreading legal awareness and encouraging discussions around equality, safety, and empowerment. We chose this topic because even though the POSH Act 2013 is a major step toward ensuring safer workplaces, many still struggle with how it's applied in real situations. Through this session, we aim to understand both the legal framework and the practical challenges of implementing POSH in the workplace. To take this session forward, I would now like to invite Shiny to introduce our esteemed speaker for the webinar. Over to you, Shiny.
Thank you, Saya. Good everyone. It gives me immense is an at Madurai bench as well as the Tiruchirappalli District Court with a strong foundation in law and with a strong foundation in law and research. He has built an admirable career that seamlessly blends legal practice, scholarship, and public engagement. His dedication to legal education and his consistent efforts in promoting legal awareness resonates deeply with the vision of the Tamil Nadu Legal Rights Consortium. He has actively participated in numerous awareness programs across schools and institutions, educating young minds on key legal and social issues, from cyber laws and privacy to broader questions of rights and responsibilities in today's world. Today, we are privileged to have him with us to share his insights on the POSH Act, helping us better understand its practical applications, rights, and responsibilities. I am certain his perspective will be both insightful and thought provoking.
Thank you. So, first of all, I warm welcome to one and all present here. and it is such a wonderful opportunity for me to connect with you all people. Thank you, Saya. Thank you, Shiny, and thank you, Tamil Nadu Legal Rights Consortium. So before proceeding with the topic and the further discussion, I would like to emphasize on the importance of this topic. The pillar of any country would be the women's empowerment. A woman can feel safe only if she is given proper education and if she is given proper independence. I would like to explain the term proper independence because most of the independence or freedom or any rights would be confined to the books. But the success of a woman will be graded only through her education and also her academic qualifications and the way in which she is excelling in the society. That's only possible through working and showing that I'm independent and I can survive on my own. Well, that being the point, these two limbs, education and also the work opportunities for a woman, becomes a must in the society, and that is how the society will be empowered. But here the issue would be when it comes for education, we are granted several neutral rights, which in one way or other will cover the educational necessities of a woman. The actual struggle comes from the post graduation or from the undergraduation itself. But the struggle will get worse at workplaces because most of the people they will be showing or they will be supporting women at their early stages. But when she comes as a competition, when she comes as a threat, these ugly practices will come into play. At that point, it becomes necessary for us to protect the women and to ensure her independence through legal mechanism and also as a fellow human being. That being the necessity, this particular Act 2013, which is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 came into place. But the struggle behind this act is also have to be noted into consideration. So before proceeding with the core of this webinar, I will be emphasizing on certain limits that I will be imposing upon. So this webinar will be proceeded for 45 minutes and I will try to cover most of the aspects and then we can go with the question and answer session. Similarly, through this webinar, I will be concentrating more on the BAR Act and the legal mechanisms because this being a sensitive topic. So we have to get a clear understanding of the legal framework and also the practical implications. So before proceeding with the 2013 Act, I would like to emphasize on how this Act came into play. Then we have to go to the time in 1990s where the women empowerment is still in theory and it was not properly adopted in India. At that point, Mrs. Banwari Lal, who was very prominent in women empowerment and also other issues like prevention of child marriage and other issues that are pertaining women, she did one impressive job of preventing the child marriage of a potter lady. And that potter child's marriage was stopped and she was saved from the evil of child marriage. But the consequences were completely taken by Miss Banwari Lal. What happened is the people who were around her belong to the feudal lords and they also have certain important influential positions in the locality. So uh, they took this opportunity to take revenge on her and they gang raped her, as a result of which the women empowerment and also the people who support for women empowerment, their safety and their security became a question here. Based on which she also approached the Rajasthan High Court, she approached the trial court and then went to the Rajasthan High Court. She was not given justice. At that point, several public interest litigations came into play and several were filed before the Honorable Supreme Court of India. One such is Vishaka versus State of Rajasthan. In that particular case, it was presided by the Chief Justice, who is none other than Justice Verma, who also played a very crucial role in the creation and also in the creation of guidelines of Nirbhaya case as a result of which we also obtained the criminal law amendments. So, with this character, with this person who respects women's right, the Vishaka guidelines came into existence in the year 1997. But the crucial part here is the guidelines solely taken the rights of women from the year 1997 till 2013. So we will be having the question how the guidelines of Supreme Court will come into play when there is no law which is fixing or which is protecting the rights of, that is intended. As per Article 141, the guidelines or the law that is given by or that is established by the Honorable Supreme Court of India in case of vacuum will act as law. So, with the help of Article 141, the Vishaka guidelines were properly followed. But the other issue came when the Supreme Court was again notified that these guidelines were not properly executed because we don't know whom to approach and how the complaints have to be presented. At this point, another series of or bunch of public interest litigations came up before the Honorable Supreme Court of India, and one such is Meda Kowal Lile and others versus Union of India, which is reported in AIR Online 2012 SC 632. Where once again the three-judge bench was addressed with the issue. Yes, we got Vishaka guidelines. Yes, we got Article 141, but still it is not implemented in a proper way. We don't know whom to approach and how to address our issues. So at that point, the Honorable Supreme Court specifically mentioned in paragraphs 13 and 17, I'm not going to explain that. In 13 and 17, the Honorable Supreme Court explained that the safe and secure environment for women is an important right and it has to be respected, as a result of which the Vishaka guidelines have to be followed, though we also know that there is no mechanism to protect the rights of people in bar and also hospitals and other institutions. I would specifically mention that the honorable courts, the honorable high courts were given the jurisdiction to entertain such complaints that were placed before them. So this was a finding of Justice Lodha in 2012 case. And immediately, the Prevention of Sexual Harassment Act, which was at the bill stage in Lok Sabha at the time of 2012, came as a law in 2013. And now, as a result of all these huge struggles, we are having the act, which is definitely doing its job of protecting the women by creating the internal committees and local committees, which are easily approachable and which are easily accessible. Now, when we get into the objective of the act, we have to once again touch the three rights or the golden triangle of Indian Constitution. Article 14 is talking about right to equality. So, a woman's right to be equal with men or any other person has to be established. And then we can go to Article 19, 1G, which is giving the right, the fundamental right to every citizen to practice their favorable profession, business, or any sort. So practicing the profession doesn't mean that you can enter the job and you can quit it on the next day. It must give you certain assurance that you can practice the job without any hurdles. So that is the essence of 19.1G. And the most important right of all is Article 21, which I would like to call, I will always mention it as an umbrella of rights, because it is given the widest connotation that you are having the right to life and personal liberty. The life and personal liberty will always get updated. From the time of Corona, we got the new right, that right to have a virtual connection or right for the internet also becomes a part of fundamental right when everything is connected through the network systems. Similarly, Article 21 is not only giving you a right for safety, it is specifically protecting women by saying it is not only right for safety or right to work at a place, it includes the right for safe environment from sexual harassment because it falls within the ambit of dignity. So Article 21 is not only giving you the right to work, but a right to work with dignity. So with these three articles, we also must take into consideration Article 15, which is a special provision where the parliament or the legislature, any legislature is having the right is having the power to create special laws for women and children. So here comes the 2013 Act, which is specially created for women because the aggrieved person can be a woman and she can only approach the internal committee and it is not for men. Apart from this, from the objective of the Act that is mentioned in the Act itself, we can see that India is also a signatory for Convention on the Elimination of All Forms of Discrimination against Women. And India ratified it in the year 1993 itself. So with these obligations and with these heavy bound duties, though despite having these, India created its act only in the year 2013 after an unfortunate gang rape incident and an unfortunate reminder that the guidelines that were strict were not properly followed till 2012. So this is a backstory we must be aware of before proceeding with the 2013. Now let us split the webinar session into two. First, I will be concentrating on the definitions. So what are all the definitions or terms we have to be aware of when we read this app? First, we have to concentrate on aggrieved woman, section 2A. So from the term itself, we can understand it is pertaining only to the rights of women. So it is only for the protection of women. A man cannot step into her shoes at any point. So the controversial point with respect to this definition is any woman of any age, employed or not, who alleges the sexual harassment. So this is one ingredient. Here we can see the term employed or not. So what does it mean? Whether she must be in strict employment or not. That is why we have to link it with the definition of employee, where it is also inclusive of interns, probation people, and the people who are engaging in the work or who are in the course of employment, who are trying to get the job. These people will also come under the category of employee. So there's no need, or you cannot take the literal interpretation that the person must be specifically employed in the particular organization. She can be employed or she may not be, but it must be related to work. That would be the only consideration that will be checked while looking into this complaints. And the second point would be the most interesting point here is it is not only pertaining the organizations or institutions, it is also extending to dwelling house. That is, the right is extended to housemates too. In dwelling house, any person who is the authority or who has employed the particular housemaid, that person will be considered as an employer and that housemaid will be considered as an employee. So interestingly, this 2013 Act's ambit is extending to housemates too. So all the women are protected. Any woman who is working is protected. Any woman who is trying to work is protected. And the second definition would be, who is a domestic worker? So section 2E once again explains the domestic worker can be a person who is employed or who is having an household work. It can be, she can be getting the remuneration in cash or kind. In many villages, we can see that the remuneration is given in kind, like she will be given 3 meals, she will be given the utilities, she will be given the groceries. So this kind of practice still exists in certain rural areas. Well, that being the point, the person who is getting only remuneration in cash, if she is protected, there won't be any objective to be fulfilled by this act, because it has to protect any person who is working, irrespective of remuneration, irrespective of the institution. Well, that being the point, here the remuneration can be in cash or kind. And the next important point would be, we cannot go and directly approach a person if a person is in a, you can consider a situation. If a person is in an urban area and he cannot approach the person directly, then he will automatically engage a person through agents. So at that point also, a person who is directly appointed or who is appointed through an agency is also coming under this ambit of domestic worker. And then let us go into the important definition of employee. So employee is defined in section 2F. A person employed at a workplace for any work, it can be any work, It can be the person employed, can be a regular employee, a temporary employee, a person on contract on an ad hoc basis. She can be on daily wages. She can be appointed direct means or through an agent, through a contract. It can be with the knowledge of principal employee, that is, with or without the knowledge of principal employee. So the ambit is so wide that it is covering all the possibilities of employment. So there are several occasions when a contract is being established through an agent. The person can take an advantage, like, I am just an agent, so you had to go for principal employer if, in case of any problem. On the other hand, the principal employer will be saying, no, you are appointed only through an agency. So the agency is directly responsible for you. So you cannot approach me. So to avoid all these confusions, the employee is given a very big ambit, like the remuneration is immaterial, the period of work is immaterial, the mode of work is also immaterial. It can be of any work. The method, the string through which she entered the job is also immaterial. It can be a voluntary one, or it can be on a direct basis. Nothing is material here. She must be in employment, she must be at the workplace, and she must face discomfort. While that being the point, she will be considered as an employee, and if she is affected, she becomes an aggrieved employee. And the next important definition would be employer. So who is an employer then? We know who is an employee. On a general understanding, we will come to a conclusion that a person who is having the absolute authority must be considered as an employer. But this is not possible when the workplace is having different stages of control or different stages of hierarchy or different departments. So when we consider an institution that's so big, we can take a department as an employer as well. The department's head will be considered as an employer. Okay, what about a big group that is having a full control? Like my manager is having the full control. He is not the head of department. Then that manager will be considered as an employer too, because he is in a position to exercise some direct control over you. And then, what if the workplace is not properly covered? Like, I don't know who is actually holding the power. Then the person who is having the management control, who is having the supervision, the supervisor, he will also be considered as an employer. It can go for a team leader when it comes to a particular small groups. For domestic work, the person who has appointed you or the person who is benefiting from you, everybody falls within the ambit of employer. So with this wide definitions for employer and employee, the next core definition would constrict itself to workplace, because if this wide connotation is given, then the possibility of misfortune incidents or the possibility of the other way around too, like misusing this act, will also come into play. So you have to link it with the employment. That is only possible through defining what is workplace. So what workplaces or what institutions are covered under this act. So workplace is defined under section 2O. As previously discussed, in case of employer, everything will come under the workplace. For department, you can say the groups, you can say the supervising committee, you can say everything will be coming under the workplace. For private sector organization, we can consider the private ventures, non-governmental organizations, everything. So once again, it is giving a wider rank. The interesting part here is it is not only covering the government and also the non-governmental authorities. It is also specifically mentioning that certain workplaces will also come under the same, like the hospitals or nursing homes. Now you can link it with 2012 Act that we have discussed, because that is one concern raised by the writ petitioners, that there's no proper mechanism to address this in bars or hospitals or nurse wards. So hospitals or nursing homes. Another interesting inclusion is the sports institute, stadium, sports complex, or competition arenas. So we can also have a doubt in what way sports is related. What about athletes then? The women athletes who are competing in the particular competition, and her safety must be ensured, because it is the work for the women athletes who are engaging in sports. So the sports institute, everything is included. And the fifth point is any place visited by the employee arising out or during course of employment. Let us take an example. The person is engaged in the corporate social responsibility, and the person is assigned to visit a remote area, and in that remote area, she is facing the problem. You can take the example of Vishaka versus state of Rajasthan case, where the Mrs. Devi Madam also faced the same issue. She was assigned to do a job, and she went there. She faced sexual harassment. So won't it come under the workplace definition? Yes, that will also come under the workplace definition. So what will be the limiting aspect here? Only it has to be in the course of employment. But you cannot take it strictly as per the labor laws too. So we can see that it is both covering the wide aspect and also specifically mentioning that it must be in furtherance of the work. If it's not related to the work, then you cannot go with this act. Then obviously, as we have discussed the definitions of domestic worker and also the housemaid, the dwelling house will also become the workplace. And the core of this particular webinar is the definition of sexual harassment. Though it is sensitive, I would be of the opinion that the doctors and lawyers and any person who are interested in getting themselves aware of the women empowerment must be knowing the term sexual harassment, how this particular act defines sexual harassment. So the sexual harassment is defined under section 2N, where it can be one or more of the following things. So first category comes under the unwelcome acts, and the second category comes under the behavior. So unwelcome acts, as the name specifically mentioned, it must result in some inconvenience or uncomfortable approach towards the woman. And the second one would be the behavior. So it can be a direct behavior or it can be an implied behavior. To give a clear understanding of, because once again, this is giving you a wide ambit. Any slur or any irritating word will come under the unwelcome act definition. Or sometimes an agitated approach may also come under the definition of behavior. So that being the point, there is some necessity to create certain ingredients so that this will be helpful in interpreting the act to check whether the act comes under the sexual harassment or not. So the first one being the physical contact and advances. As the name specifically mentioned, if there is physical contact and if there are some approaches for physical contact, that will come under the sexual harassment. Second one, demand or request for sexual favors. So approaching a person for sexual favors and requesting for it comes under the sexual harassment. Making sexually colored remarks. So making some opinion in the guise of criticism, making some sexually favored remarks, like in the guise of giving a criticism or in the guise of giving an appreciation, if it is resulting in sexually body shaming or sexually making those remarks, these will come under the sexual harassment. And showing pornography. This is also a part of section 2N. And any other unwelcome physical, verbal, or non-verbal contact of sexual nature. So even the gestures which are not appropriate cannot be done in the workplace. So with these 5 ingredients, we can link and we can say that the sexual harassment is dealing with certain types of approaches that must not be done in workplaces. So it is not excluding all the behavior. It is excluding the behavior that is making some sexually inappropriate opinion in the mind of women. So it can be the physical acts, it can be the behavior, it can be those unwelcome acts. So these are all the essential definitions before entering into this, entering into the practical framework of this act. Let us get into section 3, prevention of sexual harassment. So we know what is who is employed, employee, and what is sexual harassment and what is workplace. So how we are going to prevent the harassment and these unfortunate incidents in the workplace. So it is giving, it is putting a limit, or it is putting a specific prohibition that a man cannot engage in implied or explicit conduct which will be towards certain work benefits or work deterrence. In workplaces, a woman will be subjected to sexual harassment for only two reasons. Either it will be by luring them for preferential treatment, or by threatening them that they will be subjected to some penalties, or they will be subjected to demotions, or they will be fired. So only for these two reasons, or based on these two approaches alone, the sexual harassment will be approached, or the person will be approaching a woman with a bad intention. So what are all the possible options or possible methods through which the person will be approaching a aggrieved woman? First one, preferential treatment in exchange for sexual favors. So what would be the preferential treatment here? A hike, a bonus, a promotion, a compliment, or you can also say that she will be considered for the head position. These are all the preferential treatment. Okay, then what about the detrimental treatment? Yes, you will be fired, you will be demoted, you will be suspended, you will be put on bench, you won't be given the proper salary, there will be some deductions like this. These will come under the detrimental treatment. And another, some cheap approaches will also be made, like the making the environment very hostile. If the person, if for example, the alleged person is a manager, what he will do, he will target that particular woman and he will say, he will make her environment very shabby. Like she will be given more work, or she will be assigned more important works with very limited timeline, or her desk or her particular cabin will be bombarded with a lot of unnecessary documents, or unnecessary records will be kept at a place that will be making her feel very inconvenient. And there will be certain clear interference with work. Like there will be an important project she will be undergoing and she has to complete within 2 days. Let us consider this to be the situation. And immediately that manager comes and gives her extra 5 works of his own. And he says, if you don't complete it, then I will report it. Or I will give you some black mark and I will mention that you are not a capable person to work in this department. So he can make the environment very hostile. And the last cheap and very disgusting thing would be humiliating treatment in front of others, like publicly criticizing and making some shabby remarks, making sexual remarks, or intentionally questioning her health or safety, or making any such remark that is not appropriate or that is unjust, and it is towards the sexual harassment means. These things will be the reasons, or these things will be the possible ways through which the person who is said to be an employer or an engaged person can take advantage of a woman. So what does the act say? These kind of treatments, these kind of acts by the employer or a person engaged in the particular workplace cannot do against a woman. That is what Section 3 is talking about. Fine. So these are all the prevention methods. But what if the person didn't comply with it? That is a place where the internal committee and local committee will come into play. So internal committee is presided by the woman, of course, it has to be, and 2 people who are having the engagement in women empowerment. They must be having a very good cause and intention, and 1 person who is not belonging to the government organization. That is, a person must be from non-government organization, and these people will be forming the internal committee. For example, you can take my situation where my father is the internal committee member in Srimati Indira Gandhi College. Here, why I am mentioning this is my father is falling under the category of the 4th thing. That is, a person who is not belonging to any organization. So I will be the independent person there. So any internal committee complaint that is received, it will be easy for the person to view it without any bias. And then let us go into the local complaints committee. Here, another interesting part which you have to take into consideration is the Act's um, very clear objective towards the possible issues. Because we know that if there is a need for internal committee and if the institution is having less than 10 people, then consider the situation. There is a high possibility that the person who has engaged in the very act itself will be the part of the committee. For example, if the institution is having only 9 people, then the formation of internal committee for that particular department or for that particular institution will be highly improbable. And also for unorganized sectors, the day-to-day sustenance will be of a major issue. So the person or the particular unorganized sector department will not be in a position to form the internal committee. To tackle these issues, that is why this act is also proposing for local committee. The local committee is established in block, taluk, and tehsil basis. So the person who is aggrieved by the sexual harassment by the engaged person, so employed person or an employer, then she can approach the local committee and she can hand a complaint then. What if the person to whom you are addressing the complaint itself is engaged in the unfortunate act? Then this local committee will come into play because this being the neutral body. So there's no need that you have to confine yourself or you will be forced to give a complaint to the person who is engaged in the act. You can go to the local committee and you can say, this is the reason and that is why I am filing the complaint here. So this is section 4. Then how can you make a complaint? So the complaint has to be in writing. Then what about the people who are uneducated? Because these unfortunate things are targeted towards the weaker section of society. Then don't worry, the committee will be assisting you to make a complaint in writing. You can dictate it and there will be a person to write it. And then what is the limitation here? Again, the interesting part would be a woman will struggle a lot to give up her dignity and report these incidents. It is not an easy task because it is not, she respects her dignity more than life. Well, that being the point, is there any strict limitation that you have to make a complaint within these days? Yes, you have to make a complaint within 3 months. That is okay. But you are also given the leverage because it is not for a single incident. 3 months from the last incident in the series of unfortunate incidents you have faced. For example, if she is subjected to continuous unfortunate acts, then she can take a look at it. She can wait till her patience is worn off and she can go and file a complaint. So it is not on a strict limitation basis that you have to make a complaint within the 3 months. If it is not so, it cannot be considered. Then if it is filed beyond 3 months, the woman can explain that for these reasons, for my shyness or for respecting my family, to make the problems not to escalate. So these are all the probable reasons based on which a woman would be delaying the thing. Either it will be for her dignity, for her family or her peers. When she is of the opinion that my rights are very important and the opinion of others are not material to me at all, then also she can approach, she can make a complaint and she can say, that is why I couldn't file within 3 months, but I don't want the bad person to leave unharmed. I want him to feel the pinch. Then also the complaint in writing will be accepted. So another possible probability would be, what if the person is a very unfortunate person, like she is having some disability. Because of those incidents, she is mentally disturbed or she has lost her sanity or she is bedridden or she is having some physical debility based on which she cannot make a complaint. Then her heirs, legal heirs can make it. Then section 10. So the beauty of this act is it is not only defining the sections, it is also making the act go on a very step-by-step way. See, from the sections arrangement itself, we can understand that before proceeding with the uh, inquiry, they are making possible ways to reconcile the issue, or to make the issue de-escalate. So after dealing with the authorities, after explaining the terms, after giving you that how you have to file a complaint, it is introducing the section for conciliation. In conciliation, before initiating with the inquiry, that is before complaint turns into a particular case before the internal committee or the local committee, the agreed person is given an option. Now, with the permission of the agreed person, the possibility of settlement can be taken into consideration. But here, the conciliation's unique point is it is not allowing for monetary compensation, because it cannot be used as a particular section for extortion of money. So the conciliation is made towards the towards what? Towards giving first aid to the already strangled relationship, to make some amends, to come to a consensus in a very positive way, not at the detriment of the person, or not encouraging a person for fake complaints, because it is not allowing any monetary settlement. So when the settlement is proper and it is done and an amicable solution is brought, then the settlement will be recorded and it will be forwarded to the employer. So once the settlement is arrived, there will be no further inquiry. That will be closed and that will not be made public. So everybody can go to their paths. But if the agreed person thinks, no, this this bad person must not be left, and he must be prosecuted, he must be brought to justice, then she can go for the inquiry. In inquiry, which is mentioned in section 11, the inquiry of the employee will be done on the service rules of the particular institution, because each and every institution will be having its own service rules and regulations. They will follow it. They will conduct the inquiry. And here, the internal committee will also act as a court, because it is having the power to summon the witnesses, to record the evidences, and to make the observations, and then only they can give the particular finding. So with the power of the civil court, it also appreciates the evidences. But we can also have a skeptical mindset. What if it is going to be a prolonged proceedings? Once again, the evidence will be appreciated in a very strict sense. No, that is not like that. They will be taking the service rules and also the evidence aspects on a very limited basis. And their role is to make one finding, whether this person is guilty or this person is innocent. If this person is innocent, and if the inquiry finds that the complaint is malified, then they can take action against the person who made the malified complaint by suggesting it to the employer that she can be proceeded as per the service rules. If the person found guilty, then automatically what happens is the person against whom the finding has been given will be subjected to all the penalties in the service rules, and also the report will be forwarded to the employer with the finding that they can make complaint as per the IPC. Now, Bharatiya Nyaya Sanhita. They can make that finding that you can go and file an FIR and he can be prosecuted. And then another finding can also be given that the disciplinary proceedings as per the service rules can also be taken. So these are all the two implications. This is how the inquiry will be proceeded. But to ensure that the inquiry is done in a very safe way, you cannot possibly make the victim and also the perpetrator on this in the same workplace. So you can give leave to one person. Once again, another issue would be this may not be used as a point for termination of the person who is taking the leave. This leave will not be considered. This leave will not be considered for labor law issues. This leave will be excluded when linking it with the employment contract, that it is not connected with the permissive release. It is a forced relief. And again, the another possibility would be transferring the agreed woman from the place to another department or to another branch. In that way also, they can ensure that the particular inquiry is done in an unbiased, neutral way, and also it will not give opportunity for the perpetrator or the really bad person to once again threaten the person to withdraw the complaint. So what you have to do? The internal committee will be having a very strict timelines that within 10 days they have to file a written report saying that this is my finding, that person is either guilty or not guilty. If it is not guilty and the complaint is somewhat convincing, or it is not that of a big issue, then it is okay. If the person is found to be guilty, then FIR can be registered against him and the finding will be given to the employer. Disciplinary proceedings will be proceeded against him. If the aggrieved person made a very malified complaint, then action can be taken against her too. So these are all the three possible situations. Again, the next question here would be, so here you have made the transfer, you have made my life complicated, you have also given me forced leave. So what will be my compensation? Like I also faced some trauma. I went for some medical treatment. I had several issues because of which my family life also disturbed. So these are all the other factors that you have to consider for an aggrieved woman to know to what extent the person has suffered. For that also, the Act is giving you certain provision. Section 15, it is dealing with the determination of compensation. On what basis the aggrieved woman will be given compensation? First one, mental trauma, pain, suffering, and emotional distress caused to aggrieved woman. Second one, loss in career opportunity. Just imagine a situation. This will be a perfect opportunity to blackmark the person. So what they will do, they will make a very false allegation, like she's very haughty and she always does this short-tempered things. She will be making these baseless allegations. If it is made it in such a way and the person wants to make a transfer or wants to shift her job, then she will be at the loss of career, her loss of opportunities, the medical expenses. Let us consider that she is very psychologically affected, she is undergoing psychological treatment. And what about the, if there are some physical acts too, she is undergoing treatment for them. You can consider that under the medical expenses. Then income financial state, because of which she is made to lose her promotion. Like because of this pending issue between the employer or the person and the aggrieved woman, she is not considered for other job opportunities, other better projects. Then the income and financial status. Then feasibility of such payment by the other side. If it is going to be too enormous, then obviously other person will not do it, and that will be an impediment on the person who has actually done it. So by considering these points into mind, the inquiry report will be also giving a finding on the compensation that can be available for the aggrieved woman. Then another important aspect in this social media world is we will be of the opinion, or the content creators who want to create some viral topics may take it as an opportunity and they will make these contents, these sensitive contents, public. To avoid this also, the Act also prohibits publication of these information in public forum, in official websites, or any such. But what if the person wants to record it as a win towards women empowerment? Like this person won it, and there is an opportunity to take some really good measures if the person is at fault. Then you can make the news on it. You can hide the name, you can hide the incident, you can hide all the details, and you can say that this complaint can be made for incidents and it is allowed. So this kind of confidentiality clause is also there, section is also there in 2013 Act. So again, if there is a prohibition from making these publications, then there must be some deterrent provisions too. For example, if the person who is engaged in the computer department and who is making such publication without making a very open and by making the names very explicit and making the details very clear, then the deterrent action can be taken against the person also. And what if the inquiry is not satisfactory? Then automatically you can also prefer an within 90 days of recommendation as per the service rules and tribunal. And excuse me, because of some event in my neighborhood, there is some noise issue too. Please excuse me for it. And let us get into section 26. Let us wrap up with this particular section. So it deals with duties of the employer. Educational is the institution or the person who is in the employer position wants to create some awareness. Then he has to um, engage himself in certain events also. For example, he has to make the um, make the provisions of Prevention of Sexual Harassment Act public. He must create awareness. He must engage himself in security.
I request participants to wait while Sir joins us again. He is facing some technical issues.
Hello. I'm extremely sorry for the inconvenience. Due to some noise issues in my neighborhood, I'm going to give a short pause. So, when we come into section 19, employer's duty say that the employer is having certain obligations to make the Prevention of Sexual Harassment Act known to their employees and known to people who may possibly get affected by it. So their duties involve creating a safe working environment and also display of penal provisions and the act in public places so that it will be helpful for the person to refer it and also follow the act's principles. And they have to engage in awareness programs and orientation, which you can see in case of educational institutions. There will be several conferences and awareness programs to help people know more about the POSH Act. And they must also support the committee in making proper inquiry, and they give some accesses like the witness accesses and certain opportunities to the internal committee to make their inquiry reports in a very unbiased and neutral way. And they have to assist the person, agreed person, in filing the FIR too, because their inquiry's main objective is to bring the bring the culprit before the law and also the assist the woman in empowering herself. So they have to assist the woman in filing the complaint as per IPC or BNS so that she can proceed with the penal action against the perpetrator. And treatment, and they have to ensure that these kind of activities must not be done. So they have to consider this sexual harassment as a misconduct and the proper disciplinary actions must be taken against them too. And let us get into section 26. Section 26 is also imposing certain fine on the employers. So the employer's duty is not a ticket option. They are not given an option here. If the employer is not doing his duties as per the provision, as per the act, then the fine can be imposed on them to an extent of 50,000. And if it is repeated, then double penalty can be given to, and it may also affect their registration. So, with this clear outline that is given in the POSH Act, we can understand the definition of workplace, employer, employee, the wide ambit of it, what is sexual harassment, and section 3, which is dealing with the prevention of sexual harassment in workplaces, and the duties of employer, and and how genuine the internal committee has to act, how the inquiry must be done, and what is the timeline with respect to the inquiries, and what if there's a possibility of settlement too. So all the possible options have been covered under this act. So this act is, we also may be having certain doubts with respect to the penal provisions of this act. So if the disciplinary action is the only solution, then what is the main objective, or what is the uh, intended deterrent effect of this act? For example, consider the situation. If the person who is engaged in this unfortunate act is doing a very good job, and he is having a family, and he is having a very good reputation, this will create a definite black mark. Moreover, this will stop him from making some good career growth. And again, not only his reputation, not only his family, it will be the black mark on his dignities. Apart from that, if the action can be taken as per IPC, we know that the IPC is having the continuity of offences option, where you will not be constricting yourself only with the sexual harassment. That is the provisions from 72 to 76. If there is a possibility, or if there is an attempt of rape, or if that unfortunate incident happened in continuance of work, um, in continuance of work favor or work deterrent treatment, then also the rape in the guise of uh, workplace favors will also be brought under the purview. Apart from sexual harassment, apart from nuisance, we can also go for voyeurism and other offenses that are targeted towards women. Apart from that, we can also go for stalking provisions. So there is multiple opportunities in IPC. And when we club all these sections together, that will be imposing a very big imprisonment or punitive measure on the agreed person, apart from the black mark on his dignity. So this act is supportive on its own, and this act is complete, and this is a very good established act. But the only issue here is being that we are not properly aware, or we are not properly educated about this act, and we don't know how to use this act or lodge a proper complaint as per this act. That is the only impediment. If these things were properly addressed, and this awareness is created, and it is reaching all the people, and if the women are also of the opinion that my workplace is important, my family is important, everything is good, my career is important, but it must not be at the cost of my dignity. If that mentality is brought in, if her independence, freedom, and confidence is boosted, then obviously this act can be put on in a very good place. And it will be of definite use to any person who wants to, or any woman who wants to empower himself, empower herself, and contribute to the society. Thank you. And with this, I'm completing my lecture. We can go with the question and session.
Thank you so much, sir, for such an amazing and a really engaging session. I'm sure everyone here has learned a lot about how POSHAK actually works and how a little more awareness can make our workplaces safer for everyone. Now we'll be moving on to the Q&A session. Participants, if you haven't already, please feel free to drop your questions in the chat box. We'll take them up one by one.
So I came across two questions. How can the POSH Act be made gender neutral? This cannot be made gender neutral because it is in furtherance of Article 15, which is a special provision. So we cannot go for a gender neutral. That on a very short outline we can say. But for safety of men, the gender provisions are there in IPC, and the main intention for creating this act is the hesitance of the people or hesitance of the women to approach the forum because they will be giving more importance to their dignity, family, and their career and work style. So, if that is the point, the safety has to be given to the women, and the point of making it gender neutral will um, actually break this act. So, it cannot be made gender neutral. And what role can so that question was asked by Mr. Mohammad Yashid Bhatt, and the second question was asked by Deepak Chenoy sir. What role can law students like us play in spreading WASH awareness? Very simple, brothers. By engaging ourselves in these webinars and making some good questions like this, so we would be having a detailed discussion. And if there is any update too, we can have a good discussion, and based on which we can create awareness by having engaging talks, and we can make research articles. We can also be a part of the marketing or promotion person when it is for posh conferences or awareness programs that is done by the institution in which you are associated. For example, TNNLU will be also doing the role of creating awareness for posh. So we can be a part of it, we can promote it, we can learn from it, and we can update ourselves. So in these ways, we can be a very good role in creating posh awareness. Next, the question is by Mr. Dhruv Bhashan. So, what is the obligation of citizens to uphold and ensure effective implementation of the POSH Act? I'll be very making a very hypothetical answer here because a citizen's role would be if it is for general awareness or general treatment, we would be making very tall claims like I'm a very supportive person. I'll be supporting my woman or my female friends. I'll be doing that. But if the person is entangled in real life situation, we will be the person. We will be the first person to judge that woman. So she may be having some really such kind of things, or she may be bad. He may be bad. We will be the first person to take the uh, view, and we will be the first person to judge it. So, as a role of citizen, it would be to support the person who is actually engaged in the inquiry, to not come to a conclusion, to wait till the inquiry report, to wait till whether the complaint is good or the person is good, to wait till the chit is clear, or to just stop being judgmental. That would be good. And the next question is by Ms. Harshita Mishra. How can small businesses and informal workplaces better comply with POSH given their specific constraints? Yes, madam, that is why we are having the local committees. Because if it is a small business, the person running or the people engaged there will be 8 to 6 people. You can take it for a rough consideration. If the members included there are only 6 or 5, then there's no possibility of creating an internal committee. So how they can comply it would be to be very conscious and also to respect the other person, a fellow human being. And for grievance also, the person who is aggrieved can approach the local committee. So this act is giving the specific outline. But the solution or the answer for being a responsible person and also being a good person to promote women empowerment would be he must be morally very conscious, and he must know that the person who is in front of him, if she is a woman, she is working, that means she is having a life, and you must not take advantage of her at any point. You must not harass her, and you must treat her as a person with life and full of rights, same as her. That's all. And next question is by Ms. Srinath Khan. So, how effective the Post Act has been? Actually, it is pretty effective because most of the educational institutions and big institutions have formed the internal committee, though there are strictures by the Supreme Court that you have to form the committee and you have to take the steps. Um, there are possible options. Like if the person engaged in the internal committee is at the wrong, also you can go for the local committee. And if the internal committee is not sticking to the guideline, also, then you can make a complaint and you can make sure that the particular inquiry is done in a very neutral way. The issue is not being effective. The issue is the lack of awareness with the people. We are aware because they have to, these reports have to be written and they have to be submitted before the authority. If it is not done, if it is not properly maintained, then automatically they will be at the issue too. So the problem here is not having proper awareness. So it is effective. Next question is by Ariba Jalal. So two questions it was asked. How can laws be strengthened to protect women working in the gig economy and unorganized sector? As mentioned, for this particular act, we have the local committee to approach. But when it comes to other laws, then automatically the act with such a thought like POSH Act can be enacted by making that they can approach the government authorities in case of any issues. So in that way, by creating the redressal forum, this will be helpful. So that would be the very good way through which the law can hear the affected person and help them. And what legal reforms do you consider urgent for achieving substantive gender equality in India today? So my honest opinion would be we are having laws. The implementation is the issue. So if they are properly implemented, and if each and every woman understands that it is they are having certain rights. On the other hand, certain people who are misusing the rights, like a well-educated, married, and well-knowledgeable lady with all her freedom rights and no disturbances, taking the DVC case only for the domestic violence case, only for matrimonial issue, without any cause of action or without any that allegiance. So, by avoiding misuse, by proper implementation, if the acts and laws reach the target audience, then it is good. We are having good reforms, sir. But we are not. These laws are not properly implemented. That is in the hands of the authorities and also people. We people as citizens. If a woman student is facing some sexual offense in her university, would that be considered under POSH Act? Yes, we can make a complaint to the internal committee. The question, yes. So the next question is the effectiveness of. Okay. So he has made a comment. Fine. I think I have answered all the questions.
Thank you, sir, for the clear explanation. With that, I would now like to hand it over to Sai Nikita for the oath of thanks and to formally conclude today's sessions. Over to you, Sai Nikita.
Good morning to everyone present here. On behalf of the Tamil Nadu Legal Rights Consortium, I extend my heartfelt gratitude to Advocate Prakash sir for delivering such an insightful and thought-provoking session on POSH in practice, understanding rights, responsibilities, and realities. Your detailed explanation of the POSH Act and your practical insights on workplace rights, compliance, and inclusivity have truly deepened our understanding on how the law translates into everyday professional conduct. I also extend my heartfelt gratitude to each and every member of the organizing team for their relentless efforts and dedication in making this webinar a grand success. We are also grateful to all the participants for making this session interactive and meaningful. Sessions like these remind us that creating a safe and respectful workplace is not a legal duty, but rather a collective responsibility. Thank you once again, sir, for sharing your time and expertise with us. Thank you, everyone, for your attentive participation. Thank you.
We request all participants to please switch on your cameras for a few moments so that we can capture a group screenshot of today's session. The feedback form link has been shared in the chat box. Please make sure to fill it out as e-certificates will be provided only to the participants who complete the feedback form. Your feedback helps us to improve and plan even better sessions in the future. Thank you.